Assalamualaikum and a very good day. My name is SITI ATHIRAZATTI binti ROHIZAD. So for question 1, the issue is that whether Kamal can file for prohibitory and perpetual injunction against Shifa to prohibit her from flying the drones in the residential area which invades the peacefulness of Tri village.
Assalamualaikum, my name is SYAZWINA and today I would like to continue our discussions on the authority of question number 1. But before that, we have to know the meaning of drone is. So according to Merriam-Webster, drone is an uncrewed aircraft system which the pilot is substituted with remote control or onboard computer, meaning that drone is operated without the need of human skill, unlike the usual aircraft where we need a pilot. So we don't need a pilot in a drone. So in Malaysia, there are 3 types of drones, namely small unmanned aircraft system, unmanned aircraft system of more than 20 kg, and the last one will be small unmanned civilian aircraft system. So this kind of drones are equipped with camera and microphone, but it should be noted by all that the operations of drones are administered by Civil Aviation Act 1969. Thus, small unmanned civilians aircraft system or drones will be discussed in this matter since it has camera and microphone. On the other hand, injunction is a preventive relief where the court will abstain or order the defendant to perform a particular act, and it will be on the court discretions. The general principle is provided in Section 50 of SRA and Court of Judicature Act 1964, where the stated injunction can either be perpetual or temporary, whereby in Section 43, 44 and 80 of Court of Judicature Act, it only highlight the power of the High Court to grant a temporary injunction before it can be brought to the higher court of appeal and federal court. Based on the equity principle, injunction is usually granted in case where damages is not an adequate remedy. Moving on to perpetual injunction, in this subject matter, it has been mentioned under Section 51 subsection 2 and Section 52 subsection 3 paragraph C of SRA 1950. According to Section 51 subsection 2, injunction also may be granted whether expressly or impliedly to prevent the breach of an obligation existing in the favour of applicant. Additionally, Section 52 subsection 3 paragraph C of SRA explains the circumstances where the court will actually grant perpetual injunction. It is when pecuniary compensation is not an adequate relief, meaning to say that damage done is unrecoverable by money, so injunction will come into force.
Another type of injunction is prohibitory injunction, where the court prohibits a certain act of an individual or to restrain him from continuing to perform such acts. So according to Section 53 of Specific Relief Act 1950, the court can exercise its discretionary power to permit an injunction to prevent the breach complained of. Illustration E provides that A had threatened to publish statements about B, which is punishable under the Penal Code, and that the court allowed an injunction to forbid such publication from being disseminated to the public. Furthermore, Section 143, Subsection 1 of Civil Aviation Regulations 2016 states that the act of flying a small unmanned surveillance aircraft, in this case specifically drones, over any designated area such as for residential purposes must get authorization from the Director General beforehand. And not only that, according to Section 19 of Civil Aviation Act 1969, the flying of drones above ground of any property is permissible as long as it is flown at a reasonable height, so no trespass or nuisance have been committed in that circumstances. To further understand what constitutes reasonable, the case Bernstein of Leigh Barron and Skyviews and General Limited can illustrate this principle. In this case, the pilot must observe the flying regulations, and trespass only occurs if the applicant is able to point out which activity by the aircraft can be considered as trespass. In other words, if such activities disrupts the enjoyment of others towards the land in respect of the property to which interference may be caused, thus it is unreasonable at that point.
Good day everyone, my name is SUREKHA. Now we will move on to a case that illustrates our situation. We will be looking at the case of Lai Kong Lok and Anor against Ting Si Ling. In this case, the plaintiffs argued that the defendant had always parked his vehicle in front or near the plaintiff's front gate, which had caused obstruction and inconvenience to them when they left and entered their vehicles into the house. the defendant also continued to park despite being informed not to park there. This caused the plaintiffs to suffer physical and mental distress. They filed a nuisance lawsuit against the defendant seeking an injunction and damages. The court held that the defendant's actions and the fact that the unlawful parking was still continuing, that there was reasonable ground to believe that the defendant would continue to park there unless restrained by an injunction. The nuisance cost to the plaintiffs was not temporary and no amount of money could compensate them. Additionally, it was not in the public interest for the court to condone the car parking on a yellow line and too close to a traffic junction. Hence, the court was justified in granting the injunction to the defendant. Now, we are going to look at how we are going to apply the case of Lai Kong Lok in our current situation. Shifa's actions definitely caused obstruction and inconvenience towards the residents of Tri Village, and due to the fact that Shifa refused Kamal's request to stop flying the drone over the residential areas, has resulted in a reason to believe that her acts will continue. This will only lead to the residents feeling physically and emotionally distressed, similar to the case of Lai Kong Lok. This also further proves that she will continue to fly the drone over the properties unless legal action is taken against her, like restraining her with an injunction. No amount of money can be used to compensate the fellow residents of Tri Village for the actions committed by Shifa. Henceforth, Kamal must seek to apply for an injunction against Shifa in order to cease her from flying the drone over the residential area.
Now, applying the law to the current case, we believe that prohibitory injunction can also be applied by Kamal in this case, pursuant to Section 53 of SRA to prevent the act of Shifa of flying the drones from continuing.
Good day everyone, my name is Genevieve Ling Xin. Now I'm going to talk about the case Chai Yongden and Anor versus Tamaru Jaman bin Mayadi and Anor. The defendant's premises were used as a temple and for healing activities, which are impulse activities. The impulse activities have interfered with the plaintiff's enjoyment with the premise, such as traffic congestions, parking problems, smoke, and noises. The interference was unreasonable because the interference had exceeded the normal behavior which could be tolerated by a reasonable resident in the vicinity of the defendant's premises. So it is undoubted that the court grant perpetual prohibition injunctions under Section 50, 51 subsection 2, 52 subsection 3, B, C, and D Specific Relief Act to restrain the first defendant from carrying out any of the impulse activities on the first defendant's premises. Applying to present situations, Shiva can be restrained by an injunction pursuant to Section 52 subsection 3C. Similar to this case, as her drone flying activities leads to disruption to the residents. This is due to the noise that the drone emits through the whirring of the drone blades. Moreover, flying the drone over the residents' premises disrupt their quiet use and enjoyment of their property.
Moreover, the act of Shifa of flying the drones is unauthorized because it is not been given permission from the Director General pursuant to Section 143 subsection 1 of the Civil Aviation Regulations 2016. Not only that, even though the general rule in Section 19 provides that it is permissible to flying drones over the reasonable height, however, we believe that it is not reasonable in this case because Shifa disrupts the quiet use and enjoyment of property of others, as given in the case of Bernstein.
Moving on to the next case, Bangsan Development Sdn Bhd versus Success Portfolio Sdn Bhd, the court allowed the appeal in respect of injunctions as prior by in the plaintiff's statement of claim when the perpetual injunctions is used to prohibit the defendants from continuing to rear the pigs in their land with an open pond for collecting the pig's pieces. By referring to the present situations, if Kama were to pray for an injunction to be served against Shiva, then the injunctions will prohibit Shiva from continuing the flying of drones over the residential areas since it is a restricted area.
And for the conclusion, we can say that Kamal can file for prohibitory and perpetual injunction against Shifa in order to restrain her from flying a drone in the resident area of the tri-village because it invades the resident peacefulness and privacy.
Hello, my name is AFIFAH binti AHMAD NIZA. The issue for question 2 is whether Hazim is entitled for a mandatory injunction against KFA Sunjur Berhad for the nuisance caused by KFA, since KFA has built a building that obstructed Hazim's view of the Botanical Garden Park. So according to Section 53 of Specific Relief Act, it provides that the court may grant a mandatory injunction after found that it is necessary to compel the performance of the actions. So if an applicant wants to apply for a mandatory injunction, the applicant can apply by referring to this provision. So any party can apply for injunction before or after the trial of the cause of matter according to Order 29 Rule 1 Paragraph 1 of Rules of Court 2012. And any party also has the option to file an application of injunction by giving the application of ex parte or by giving a notice of application supported with affidavit in accordance with Order 29 Rule 1 Paragraph 2 of Rules of Court 2012. Next, there are two maxims of equity related to discretion that can waive the right of the party to apply for injunction, such as delay defeats equity. And if the party violates the maxim of delay defeats equity, then that party also has violates the maxim of the one who seeks equity must come before the court with clean hands. Now, according to Section 44(1)(a) of National Land Code 1965, it provides that the owner of the land has many exclusive rights of his property, including the right of airspace. Next, there is also doctrine of ancient light under common law that provides if the owner of the house has received the access of light for 20 years and above without interruption, then he has the right to light, and that light cannot be obstructed or closed by the owner of the adjoining land. Besides, our Malaysian law also has mentioned this right, which can be seen in the illustration A of Section 53 of Specific Relief Act, where the applicant can apply for mandatory injunction to restrain or to pull down the action done by the other party that obstruct the light access by the applicant. However, Section 2841 of National Land Code provides that no right of easement can be acquired by prescription despite having an uninterrupted user for a long period of time.
In this issue, we can see that the cafe building has affected Hazim's enjoyment from his house to view the Botanical Garden Park. Therefore, on the part of authority, we will discuss in regards of the private nuisance, whether the act of cafe falls into nuisance or not. Private nuisance is interference with the use or enjoyment of the person's land. It's not actionable per se, which means the plaintiff does not need to prove special or particular damage. He only needs to prove that he has suffered the damage. And in this matter, there are two elements which are substantial interference and unreasonableness. These two elements are interconnected and interdependent because substantial interference may fall into unreasonable interference and vice versa. There is no formula which conclusively says what amounts to substantial interference. Interference with the use, comfort, and enjoyment of the land is known as amenity nuisance. They result because of the discomfort of the plaintiff as they cannot live peacefully in their land as a result of the defendant's activity. And according to Ajit Shanaka, Rohan and Pascal in 2019, they say that mostly the buyers buy the house because of the views as it close to the beach or recreation areas. Therefore, the price of the house will become higher. However, based on James and Josephs in 2021, they say that the price of the house will be fluctuate if the view from the house is being obstructed. Moreover, the plaintiff need to prove that the interference is unreasonable. It depends on the location in which it takes place. For example, the chicken growing in the residential areas will be considered unreasonable and interference rather than the rural areas. This means that the location of the plaintiff and the defendant premises will be considered in assessing whether the defendant's activity is unreasonable and amounts to substantial interference.
Good day, I'm Lishan. I will now present to you the case that we have cited on this issue. Referring to the words of Lord Darning mentioned in the case of Feast vs. Pierce, the right to a view should be clearly differentiated from the right to light, and it should be noted that the right to a view is not covered under the law. It can be seen through the case of Butt versus Impervious Gas Light, where the erections of a building that merely obstruct views of the business premises without obstructing the light and air cannot be subject to an injunction. While in the case of Bowman Business Centres Limited, a mandatory injunction was granted on the ground that the plaintiff's right to light had been infringed by the defendant's constructions and nuisance was established. What we can conclude here is that solely the right to a view will not be entitled to a mandatory injunction as opposed to the right of light and air. Moving on, in order to substitute the injunctions by damages, there are 4 criteria laid down by the court in Shaft case. First, if the injury to complainant's legal right is small. Second, if the injury is capable to be estimated in money. Third, if the injury can be adequately compensated by a small money payment. And last, if it would be oppressive to the infringing party to grant an injunction. For example, in the case of Terminus Limited, since the plaintiff was merely deprived of its right to a view, the court refused to grant a mandatory injunction as the demolitions of the new building would be oppressive, and since the injury was small in this case, it could be compensated by a small money payment. Besides, in regard to the reductions of market price of the property due to the blocking of view, in the case of Case vs. State of New York, since the obstructions of view by the defendant's highway embankment caused a reduction of market value to the plaintiff premises, the court held that the plaintiff should therefore be compensated by the defendant.
Good day everyone, I'm Cindy. Now moving on to the applications of the case. As mentioned before, there's nuisance in Belmont, Tamarose and also K case due to the infringement of their right to light and air. However, in Hazim's situation, there's neither interference to his right to light or air, but only his right to view the green parts. So mark my word here, solely aesthetic-based complaint cannot constitute a nuisance. Hazim cannot argue that due to that he has stayed there uninterruptedly for 10 years, so he has the right to view easement. This is contrary to section 284, subsection 1 of the National Land Code. Merely annoyance due to the blocking of view is insufficient to constitute nuisance, as there is no substantial interference that caused material damage to him, and there is no unreasonableness that caused inconvenience to him. Hence, no redress can be granted to him as mentioned in 5th case. Next, if the alleged wrongdoing does not portray the needs for the court to mandatorily undoing the act, the mandatory injunction will not be granted under Section 53 of the Specific Relief Act. Referring to the illustration A of the same section and also the Billman case, the mandatory injunction will only be granted if the plaintiff access to light and air has been deprived. Bear in mind, a view is not regarded as necessity as opposed to light and air. So applying the same principle in Butt case to the present case, merely obstructing view of green part therefore cannot be the ground for Hazim to apply for the mandatory injunction, as none of his access to light and air has been deprived. Also, taking note, no mandatory injunction will be granted if the damages is an adequate remedy. As shown in Tamaro case and also referred to the criteria in Shaft case, since the harm suffered by Hazim is only the blocking of view, it is considered as small harm and it can be compensated by money. If Hazim wished to argue that the blocking of view has reduced the market value of his house, this injury is capable of being estimated by money and it can be compensated as portrayed in K case. So what we want to say is that he can only claim for damages but not mandatory injunction, because if the injunction is granted, it's made at the defendant's expenses and is too oppressive. Lastly, Hazim cannot file for an application of mandatory injunction under Order 29, Rules 1, Sub-Rule 2 of the Rules of Court 2012, because nowhere in the facts has reflected his urgency in restraining the constructions of the building. We know that build a house, it takes a long time and not just a few weeks. So if he saw that the building has nearly obstructing his view towards the green part, he should take a prompt action to apply for the injunction during the constructions of the building, but not until after the construction has completed. So he's not entitled to apply for the mandatory injunction because he has violated the maxims of delay defeat equity, and to that end, he has come with unclean hand.
In conclusion, Hazim is not entitled for monetary injunctions against KFA Sdn Bhd for obstructing his view to the Botanical Green Park. This is because it does not constitute to the substantial damage, as the building has not been deprived his right to air and light, which deemed necessary for the court to instruct for the destruction of the building.